PH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court this afternoon for the evidentiary hearing regarding an alleged violation of the court's personal protective order that was filed on or about June 10th of 2024. At this time, I'd invite Mr. Hengeveld. Would you like to place your appearance on the record?
Yes, good afternoon, Your Honor. I'm Jeff Hengeveld on behalf of Sarah Fazio.
Thank you. And Mr. Cooper Keel, would you please state and spell your full name for the record?
My name's Nevin Cooper Keel. First name spelled Nevin, last name Cooper-Keel.
Thank you, sir. And Mr. Hengeveld, this is your hearing on the alleged violation, so you may proceed.
Thank you, Your Honor. I have one witness to call, and that is Ms. Fazio. Ms. Fazio, can you please tell the court who you are?
My name is Sarah Fazio. My last name is spelled Fazio. I am the petitioner in this matter.
Okay, and are you a licensed attorney?
Yes, I am. I've been a licensed attorney for 24 years.
All right, and how did you first come to know Mr. Cooper Keel?
I sent him a cease and desist letter on behalf of the client I think it was on June 23 of 2022.
Okay.
It was the first interaction I've ever had with him.
And in response to your cease and desist letter, what was Mr. Cooper Keel's reaction?
He sent me a series, several, I don't know if I have the exact count, of emails to my office email address that were a little unhinged and made little sense. I did respond to, I believe the first one, if I recall correctly, instructing him not to contact my elderly client and to please direct future correspondence to me. He then proceeded to send me several threatening emails that he was going to sue me, he was going to sue my law firm. I ignored those to my best of my ability. And then he started up again in, I believe, January of 2022 or 23, I'm sorry. I started receiving a litany of additional emails that were more unhinged and more, that he was coming to my office and I was going to get something from him and that sort of thing. And that's when I initially filed for the PPO.
And under that PPO, the terms of the PPO, what is Mr. Cooper Keel prevented from doing as it relates to you and contact with you?
He is not to have any contact with me. He's not to reach out to me in any way. Not to send me things, come to my home, come to my office, appear within my site, that sort of thing.
Okay. And now we're here today on the motion to show cause for violation of the PPO, and I want to cover the factual basis for that motion. Were you represented by counsel in a lawsuit that Mr. Cooper Keel filed against you in Allegan County Circuit Court, that being case number 23-67017CZ?
Buckle up, because today's case is the perfect storm of arrogance, obsession, and total disregard for legal boundaries. We've got a lawyer, Sarah Fazio, who simply did her job by sending a cease and desist letter. But that one professional act sparked a chain reaction from a man named Nevin Cooper Keel, who apparently thinks that court orders are just suggestions. What started as a simple boundary turned into a barrage of emails, threats, and, eventually, this protection order violation hearing. Now, what makes this fascinating is how Cooper Keel tries to play lawyer himself, citing statutes and court rules while completely missing the point of every single one. This isn't just a courtroom hearing. It's a masterclass in how not to defend yourself when you're your own worst.
Yes, Your Honor, this violation, the factual basis for the violation relates to contact arising out of the lawsuit I just referenced, where I was counsel for her, Ms. Fazio, and I'm laying the factual foundation for why there is to be no contact directly with Ms. Fazio in that lawsuit.
Insofar you're laying it in that your argument's going to be, well, that contact should flow through you as the attorney.
Yes.
All right. Response, Mr. Cooper Keel.
My response is that the Michigan Court Rules, Chapter 7, Section 2 for the appeals court says that until an attorney files an appearance in that case, they are not representing the client. So for that to be relevant, he would have to be representing her in that case, because I think what they're getting at is that I served a copy of a motion from an appeal where she was not represented, not this other case he's asking about. So I don't see the relevance of the other case.
Okay, and response on wrong case argument, Mr. Hengeveld.
Yes, Your Honor, I was always the attorney for Ms. Fazio in her capacity as it relates to the lawsuit out of which the appeal arises. There was a motion for reconsideration filed. Whether it's my strategy or not to respond either to claim for interlocutory appeal or to not respond to a motion for reconsideration because it's not required to be responded to or not allowed to be responded to under the court rules. All of that doesn't obviate or vitiate my appearance on behalf of Ms. Fazio, my representation of Ms. Fazio. If that were the case, then you could make contact directly with a party and when they were represented by counsel. Clearly, that's not what the appearance rules.
Here's the crucial moment. A simple cease and desist letter meant to stop harassment turns into an avalanche of unhinged, borderline threatening emails. Now, any normal person would take the hint and back off, but Nevin? He doubles down. This is classic escalation behavior you see in protection order cases. The aggressor feels entitled to respond, to defend themselves, even when they've been told legally to stay silent. What's remarkable is how Fazio, a seasoned attorney, stays calm and follows procedure while he melts down in writing. But make no mistake, every email he sent after that first warning was one more nail in
has, what I'm going to call as actual notice. That is, they know that an attorney represents another person. They are generally precluded from contacting that other person directly. And the forum, that is, whether it's the Court of Appeals or the District Court or the Allegan Circuit Court or the Kent Circuit Court, is not the controlling factor there. It's the representation itself. I'll overrule the objection and allow the response.
All right, so the question again, Ms. Fazio, was, were you represented by counsel in the lawsuit that Mr. Cooper Keel filed against you in Allegan County?
Yes, I was. You were
Who was your counsel?
You were in Price Hunneville.
Okay. And as it relates to the claims against you in that lawsuit, what was the outcome?
I should say Plunkett County. I apologize.
Okay.
What was the outcome? The outcome of the underlying case in the state court was dismissed.
Okay. And then it was subsequently taken up in an interlocutory appeal?
That's my understanding, is that it was taken up in an interlocutory appeal. That's correct.
Okay. And what is your understanding of the outcome of that interlocutory appeal?
It was denied.
And after it was denied, and again, I'm going to show you momentarily your some exhibits, but after it was denied, the interlocutory appeal was denied.
Let's pause here for a quick breakdown. When a personal protection order says no contact, it means exactly that. Asterisk no contact in any form. Asterisk not email, not social media, not accidental phone calls, and definitely not legal filings sent directly to the protected party. It's not a suggestion, it's a wall. Violating that wall doesn't require physical confrontation. Just one unwanted communication is enough. Cooper Keel's fatal flaw here is assuming legal context gives him immunity. Spoiler, it doesn't. A PO violation is a PO violation, even if you wrap it in fancy legal.
Is there any date on Exhibit B for when that list was produced?
That list was produced on June 11. That I printed that off the day after I received the 11-something p.m. email from you. So it was June 11 that I printed it. I don't know on the Register of Actions if he was ever added. I think it just comes up from the state court, as every attorney that's of record in the state court.
Okay, so that was a Register of Actions from the state court, not the Court of Appeals.
No,
correct?
that was just, nope, that's wrong. That was a Register of Actions from the Court of Appeals.
Can your attorney put it back on the screen and show it to me? Because first time I've ever seen that. Well, your PPO complaint says that he did file an appearance for you in that case, doesn't it?
Asked and answered, Your Honor.
I don't know what, I don't have it in front of me.
Hang on, let me rule on that objection, Ms. Fazio. Response on asked and answered, Ms. Cooperkill, Mr. Cooperkill.
I don't recall when it's been asked and answered. In fact, they claimed that he represented her, but
Yeah,
they
he
don't
elicited
say when.
testimony that he was the attorney. Are you asking something different then?
Yes, I'm asking, when did he file an appearance?
I already answered.
And she
You're
already,
referring to the appeal in this matter.
All right,
that-
yeah.
I don't want to put words in your mouth. You might
She doesn't
say
know.
that.
She said she doesn't know when.
Okay.
So I guess, yeah,
Where things get interesting. Notice how Nevin starts quoting Michigan court rules like he's fresh out of law school. It's a hallmark of pseudo-legal logic. The idea that cherry-picking obscure procedural language somehow overrides basic court orders. He's arguing that because the attorney hadn't filed an appearance in one case, the PO doesn't count. But the reality? If you know someone is represented by counsel, contacting them directly is off-limits. Period. The judge even humors him long enough to expose how flimsy that logic really is. It's the legal equivalent of saying, I didn't see the stop sign, so it doesn't apply to me.
Me from the moment there was a Court of Appeals action.
for an attorney to appear for somebody, don't they have to file an appearance?
she asks for a legal conclusion.
All I know is that he appeared as counsel of record from the moment I saw the docket at the Court of Appeals.
How did you get the register of actions from the Court of Appeals?
It's available online.
Where at online?
I'd have to go look up the URL. I don't know.
Okay. I'm just wondering where that came from, because I don't know how to get one for the Court of Appeals.
Is there a question?
How do you get the list of register of actions?
Your Honor, she already testified. Objection asked and answered. She already testified she does not know. She would have to look up the URL, which is not on Exhibit B.
Okay, and I did.
And here's where the judge does something brilliant. He doesn't yell or grandstand. He just calmly clarifies that representation transcends procedural technicalities. In plain English, you can't pretend ignorance when you know the person has an attorney. That's how judges dismantle pseudo-lawyers, slowly, methodically, and with enough legal logic to make their argument collapse under its own weight. Notice Nevin's reaction? He's not even arguing facts anymore. He's just scrambling to redefine reality in his favor. Classic sovereign citizen energy.
I did hear that asked and answered before, and she said she doesn't know as we sit here today, so you may move on to your next question, Mr. Cooperkill.
So how do we even know that register of actions came from the Court of Appeals?
Because I obtained it from the Court of Appeals website on June 11 of 2024.
Do you think it's possible maybe it's showing the lower court register of actions rather than the one for the Court of Appeals?
No.
Okay. So you said your first contact with me came in 2022 when you sent a cease and desist letter on behalf of your client, right?
Correct.
And I responded to that email asking you, how do you think I am harassing or trespassing on your client's property? Because wouldn't I have to first be doing something to cease and desist it, correct?
I don't recall every word of that email. Do you have a copy of it?
Yes, I do.
Okay.
Would you like to adjourn for?
No.
No. Okay. And isn't it true you didn't respond with anything to my request for you to describe how you think I've even been doing that to cease and desist it?
Objection relevance, Your Honor.
Okay. Response on the objection to relevance, Mr. Cooperkill.
Well, what she said about her email contact with me in 2022 is completely false in her own direct testimony. She said I sent threatening emails then. now she doesn't remember what even was sent.
Your Honor,
Well-
may I respond?
You may.
Well, while it's accurate that I did ask a question about, I guess, the foundation for the PPO, or at least my intent to lay a foundation for the PPO, and we're not here to relitigate whether the PPO was properly issued, and we're not here to relitigate the case against that Mr. Cooper Keel had filed against Ms. Fazio's client in that lawsuit. So that's why I object on relevance.
Okay. Well, the question of relevance is with regard to are the prior emails and the content of those emails relevant? I think their existence is relevant because, after all, these violations would have come via an email notice of this register of actions. However, the content and the reasons they were utilized as the basis for the PPO are not relevant to today's hearing. I'll sustain the objection and ask that you move on to your next question, Mr. Cooper Keel.
The original case gets tossed out, and like many people who can't handle losing, Nevin immediately files an appeal. But here's the kicker. He doesn't just appeal the case, he turns it into a personal crusade against everyone involved. These filings often stop being about law and start becoming about ego. And when your appeal includes ranting about conspiracies, corrupt judges, and French Revolution-style executions, you're not appealing. You're confessing to instability on record. It's almost impressive how far he's willing to go to prove his own unfairness.
Then in 2023, in your direct testimony just now, you claimed I said to you I was coming to your office. Is that correct?
Something to that effect, yeah.
Do you have any copy of any email saying something to that effect?
The emails that are the basis for the PPO that were received in January of 2023 from you were attached to the PPO application. I don't have it in front of me, but if you want to show it to me, I'm happy to talk about it.
So isn't there no email that's been submitted with your PPO application where I said anything about coming to your office?
I don't think that's true.
Your Honor, I'd ask you to, do you think it'd be fair? I guess I shouldn't ask the judge. Do you think it'd be fair for the judge to take judicial notice of what you filed and that it doesn't contain anything about?
This is the moment where Cooper Keel's delusion crosses into danger. Paragraph 6 alone reads like a fever dream, hoping for public executions and referencing Trump's comments about the judiciary. That's not legal discourse. That's incitement language. What's chilling is how calculated it was. He didn't just vent. He manually added Fazio to the system to ensure she personally received his rant. That's obsession disguised as procedure. Every word he wrote screams contempt. For the law, for authority,